everyone. Welcome back to the Mayor Law Podcast on real estate and joint venture agreements. This is a series on JVs in depth. Last week, we went over management rights and who gets to call the shots under a JV agreement. And this week, we'll go over capital contributions. When the capital contributions get called, who gets to call them, what percentages each party pays, and what are remedies for failing to make a capital contribution. Finally, we'll talk about some of the dueling perspectives from the operator developer on the one hand and institutional capital partners on the other hand on what capital contributions should look like and what remedies should be. Before we get into it, first, I want to let you know why you should care. For starters, the things we're going to talk about in this podcast are often widely misunderstood, even among people that have been doing this for years. I've gone up head to head against old men and senior women who proclaim to be experts on these topics. And yet, when you drill down into it, you're like, that formula doesn't really make sense. So, we'll get into the nitty gritty here. And for those of you who have been doing this for a while, it'll be a nice refresher. I always find interacting with colleagues, if you're a lawyer listening, interacting with colleagues that have fresh perspectives and have different, experience over the years can be helpful. And as a reminder for those of you who are just joining in for this episode and not the prior episode, in this series, we'll be talking about a classic JV setup where you've got one kind of operator, sponsor, developer on the one hand, the one that's on the ground doing a lot of the legwork, and then a capital partner that's really just writing the checks, but they're sophisticated themselves. It's just they're not as involved in the day-to-day. So that's kind of the setup, the construct of how we're going to be talking about this JV structure. So first, we're going to be talking about who gets to call the capital. And really, if you think about this classic JV setup, it's either one of three options, right? Manager, capital partner, or both have to decide at the same time. But there's variations on that, right? So the classic example of the manager having sole discretion. This means the manager would be able to call capital from both sides at any time. At any time he or she deems it to be necessary or beneficial for the project. That is not as customary. If the manager gets to call capital, normally he or she is tied to a budget, an annual operating budget or a project budget in the case of a construction project. So if they're tied to a budget, they can call capital in accordance with the budget. And then the question is whether they can call capital beyond that. Typically, from the capital provider's perspective, they would want that to be a major decision. But sometimes the operating agreement may provide flexibility for the manager to go above that budget by a certain percentage or dollar amount. On the other hand, the capital provider may say, hey, I want the right to call capital unilaterally, right? I'm here to protect my investment. If I see things going south, if we need to do X, Y, and Z, I want the ability to call capital from you too, Mr. Manager, and from myself. So there's many different permutations. The more clarity the parties have at the outset about the business plan, the less friction there is in practice day to day. The stabilized type of asset where you're putting in most of the equity up front and really not much equity should be required later on, that's the easiest. But the construction situation or the value add project or the uncertain future project, whether it's capital markets uncertainty or construction risk, that's where these friction points come into play more, where one or both parties wants to take the reins and the other party says, no, I want a veto right or I want unilateral right to take the reins. The next real question is, what does each party pay of the required capital contribution amount? So the classic traditional method of allocating responsibility for capital contributions is just to say, pay in accordance with your percentage interest. So you own 50%, you pay 50% of any capital required. But there are, of course, permutations to this. So in certain circumstances, like the situation of construction cost overruns, sometimes the parties will negotiate that the operator will fund those 100% or will fund a greater share of those construction cost overruns because the argument is that party was on the ground. It's really their fault. Operators often push back hard on that and say, no, we are brothers in arms. We are at it together and you're getting equity level returns. You're going to share in the downside risk with me too on this. There are many other options. For example, there can be capital contribution mechanisms where over the course of the proposed business plan, there's different phases. So there's, the first phase, maybe one party pays 100% of costs until a certain point, until approvals are obtained. And then, they fund in accordance with a different percentage interest. And then, there's a true up, and then the final percentage interests are established. Or, there's a certain mechanism for funding certain costs, and the percentage interests really aren't determined until a date certain in the future. This requires careful drafting, careful attention to detail, precision, because it can affect a lot of things, including taxes and cash distributions. So want to be very careful that when you're crafting these provisions, you've really modeled it out, both in terms of the client has modeled it out in their pro forma, and you as a lawyer have understood, okay, this is how it should go. And for clarity, when I talk to my audience here as you, a lawyer, I do not mean to exclude the many, many clients and developers and capital providers and others that may be listening out there, students. Now let's talk about the different types of capital contributions that could be made. So there's obviously cash contributions. That's the one we all know and love. Then there's contributions of assets. And in the real estate space, that's most commonly land contributions or property contributions. And then there's sweat equity, someone's efforts put into the deal. So in cash, we kind of already talked about that, the percentages, how they're split, and cash is very easy to understand. Asset contributions. So when a partner has a piece of property that they're contributing to the JV and they want credit for that, the key issue is how is that property valued? Another ancillary issue, which is more legal in nature, is what are the representations and warranties, and what kind of package of goods am I getting as the JV in taking on this land? And sometimes there's a separate contribution agreement that's negotiated that has standard purchase and sale agreement type representations and warranties from the partner that's contributing the land. But in terms of the value of the land and the value that's contributed, that's typically negotiated among the partners. It's not often that partners go out and get a third party appraisal of the land, but that is possible, right? Because the partner that's contributing it, that's what they're deemed to. That's the capital that they're deemed to contribute. They're going to get credit for that contribution of the land, so they want to make sure it's accurate. For tax purposes, this typically, if structured properly, is not a taxable event. But again, you want to make sure that you've talked with your tax advisor about that. And then for sweat equity, there's many different ways to structure this. The most customary is to just give the person that's in the day-to-day, that's providing the management services, what's called a promote interest. And we'll talk about this later in a future episode on the waterfall distributions. But a promote is essentially an outsized return in the cash flow distribution waterfall outsized in proportion to the cash actually contributed. So after the project as a whole has achieved a certain either IRR, internal rate of return hurdle, or equity multiple, after that, the percentage split of cash distributions goes a little more in favor in the person that put in some effort and put in some sweat equity into the deal. And that way, that way of structuring it is typically done as a profits interest. So you're not taxed when you get issued the profits interest because it's speculative. It's only, if and when the project does well, then you get this promote interest. I've seen other JV structures where partners are issued kind of like this. I don't want to say phantom equity, but it's equity. It's like a percentage of the ownership of the entity, but with no actual cash contributed. And I find that to be a little tricky because when you get issued that has real value. The LLC or the entity, the JV, has assets. So when you get issued that percentage in the entity, you are getting issued something that has value. Therefore, that is income. Now let's talk about the typical capital contribution cycle for a development project. So initially, the developer's out there trying to get land tied up. He or she may be working with third-party land sellers, funding non-refundable deposits, and going under diligence. Diligence involves title and survey review, phase one, environmental, endangered species studies, flora, fauna, and most importantly, land use and zoning diligence. So the developer will be doing preliminary schematics, talking with governmental authorities on what can be built there. What's the density? What are the setbacks? How is this project going to pencil out in terms of economics? And so developers really do not want to spend a lot of cash before they know a project is viable. So often developers, before a JV is put in place, will enter into what's called a cost sharing agreement with a capital partner. And under this cost sharing agreement, it will provide that each party funds a certain percentage of the out of pocket cost to diligence the property and to do initial approvals work and design. And it will often provide that if either party backs out, if one party moves forward, will reimburse the party that backs out for their out of pocket costs. But if the project just falls through and neither party move forward, then both parties are kind of out their percentage share, but at least it's not the entire amount of dead deal costs. I mean, think about it. If you got $50 million project, $50 million+ project, that's a lot of that's potentially a lot of money to spend on figuring out whether that works. And a couple $100,000 may not be huge in the grand scheme of that size of a project, but if the deal goes south, then that's senior employee that they can't hire that year, for the developer, or a project they can no longer pursue because they've spent costs on a project that did not go anywhere. I could talk forever about how my developer clients hate dead deal costs, but we must move on. After the pre-development phase, typically there's a moment in time when the JV or project subsidiary owned by the JV takes title to the real estate, to the land for development. And at that point, typically the joint venture is signed, though it may be signed earlier. It's normally signed when this initial capitalization event occurs. And so the parties put up their initial equity contributions required for the land purchase or land transfer of title, and initial capital required for kind of startup matters, and the capital contribution section within the JV will provide for capital to be contributed as the development proceeds. So the parties will make their capital contributions. Hopefully they've established a very good, lien release provision with their GC. They're processing draw requests. Sometimes this is more formal than others, but there will be a process by which capital is contributed. And then once required equity is spent, if there's a construction loan, the construction lender will step in and start funding construction draws. And that's tends to be a little more formal of a process, though good owners have the process correct from the start. And the process should be the same, whether it's equity funded or construction loan proceeds funded. So during the course of the construction loan proceeds, sometimes projects can get out of balance, meaning the cost to complete the project exceed the remaining loan proceeds available for completion. And at that point, most construction loan agreements provide that the borrower must fund proceeds to rebalance the loan. They'll fund these proceeds into escrow typically, and then those escrow proceeds will get drawn down. We talked earlier about responsibility for construction cost overruns and how this is highly negotiable. Sometimes operators are funding 100% of the construction cost overruns because the argument is they are responsible. And other times the parties join hand in hand and go fund it together. And this is, again, very highly dependent on the terms and the relationship of the parties negotiated. Finally, as you complete the project, you get a certificate of occupancy. The building is either sold, if that's the business plan, to construct it and sell it, or hold it as a cash flowing asset. You're doing lease up of the property. You are executing on the vision for the project. Sometimes things don't go as planned, and additional capital is required to be contributed at that time. Maybe a tenant goes bankrupt and you thought you had a tenant to move into this property and they're not. Or maybe it's a multifamily and lease up is slower than expected and you've got to give a bunch of concessions and it's hard, difficult to make the debt service payments. In all these cases, what happens is sometimes parties are required to contribute capital. And so the JV itself needs to build in the possibility of things not going in accordance with plan. I see a lot of lawyers draft documents that are just so rigid, right? It's going to happen A, B, C, D, E, and that's it. It's not broad enough or generic enough or multi-purpose enough to cover all of the ups and downs. And one of the things that I've learned this past year, both personally and in my practice, is that you always have to also consider what happens on the upside of things. We always think about the downside, like what's the worst that could happen? How do we protect ourselves against the downside? But what's the best that could happen, right? What if we get more proceeds than we thought? What if we hit it out of the park? And that's we could talk more about that in the distributions episode uh, that will come after this. Probably much more exciting than having to put money into a project is taking money out of a project. So that's how the capital contribution process works in a typical development deal. Now let's talk about what happens if one party does not make their required capital contributions per the terms of the joint venture agreement. What are the penalties for doing so? Of course, the parties are going into this expecting their partner to fund their share of capital. They don't expect to bear the entire burden. That is why they went into a partnership in the first place. So, accordingly, there should be some sort of consequence for failing to make capital contributions beyond just your percentage interest gets diluted on a one-to-one basis. So, the two typical remedies or penalties for failing to make a capital contribution when required in the JV are member loan and dilution. So, the member loan is the party that funds the capital contribution when required has the option to fund the non funding party's capital contribution in lieu of them. So, and if there's more than one member, notice will be given to all members to fund, whether they want the right to fund the non-funding party's contribution, and it'll be pro rata. So the funding member funds the amount as a member loan. And the member loan typically bears interest at a high interest rate of 14 to 18%, though it may go as high as the maximum amount permitted by law, or it may go as low as 8%. It's really negotiable, but the typical range I see is 14 to 18%. And there should be a term on this member loan. This is a drafting thing that some lawyers just don't, they forget about, that you really should have a term on the member loan, because you don't want this member loan to be recharacterized as equity or not treated properly for tax purposes. So the typical loan is for 6 to 24 months, though it can be 5 years if you wanted it to be. And often there is a conversion feature. So this member loan, at the end of the term, the funding member has the right to either keep it as a loan and collect, or convert the loan to dilution. And dilution is kind of the second penalty. Before we get to that, I want to make one other point about member loans. A good idea in a JV is to have member loans secured by the non-funding members' membership interests. And this is just, a paragraph of boilerplate, but should it come to that and you're the one funding the member loan, it's unsecured unless the document says otherwise. So ideally, it would say that the member loan is secured by the non-funding members' membership interests, and the funding member can record a UCC-1 in the Secretary of State's office in which the member resides, or that governs that non-funding member. Because again, when you record UCC-1s against the assets of a person, you're supposed to record it in the state that they're domiciled in. Okay, back to member loan. So that kind of sums up what the member loan concept is. Dilution is essentially one party is funding, and they are getting a higher percentage ownership interest in the company as a result. But it's not just one-to-one dilution, meaning I funded an extra dollar, I get that dollar divided by the capital contributed in terms of percentage interest. It is that dollar is multiplied by 1.5 or 2 times that dollar in terms of the overall calculation of percentage interest. So there's a enhanced benefit for the person that funds to get an enhanced percentage ownership interest. And so the typical formula, it can be calculated many different ways, but the typical formula is that it'll be based on a factor of 150% to 200%. And the failed contribution is essentially multiplied by that 150 to 200% and then divided by the aggregate of the total capital contributions made to date. There are many different drafting options here. For example, in this formula, does the numerator, the failed contribution, if it was initially structured as a member loan, does it include accrued interest on the member loan? Does the denominator include the failed contribution? Meaning, does the denominator of all contributions contributed, does that include or not include the amount of the failed contribution? And if it includes the failed contribution, is it at the multiplied failed contribution, or is it just straight at the, if you don't pay particular attention to these details, you can come up with you can draft a mess that's practically unusable. You can also calculate the recalculated percentages in terms of marginal increase, marginal decrease to the member's percentage interest, meaning you calculate what gets added to the percentage interest of the funding member, and that same amount gets subtracted from the membership interest of the non-funding member. Or you can create a formula that just recalculates the whole thing, recalculates percentage interest on a whole, and it's just an aggregate formula in terms of how the language is structured. My recommendation to lawyers and to clients is always to just run through an example calculation and make sure, as the business person, that they understand it, right? That they get how it works, that there's a sample calculation. Some lawyers actually put the sample calculation in the document itself. Again, this is really preference, because if the calculation, the example contradicts the language, well, then you've created an ambiguity now for the court to apply all of its interpretive tools in resolving that ambiguity, including extra contractual evidence, which you really want to avoid in a litigation. So again, some people prefer example just for clarity. Others think it is rife for legal disputes and potentially opening up areas in a litigation that could be very costly with discovery of external evidence. But we could save that debate for another day. There are some more extreme penalties for failing to make capital contributions. And I see this more when I see a very strong capital provider, like an institutional equity JV partner, and a not as strong sponsor. And basically, the capital partner will say, hey, if you don't fund equity, this is a bad boy event. We're kicking you out, and all of the rights and remedies associated with the bad boy event apply. And that those can mean loss of the promote. It can mean buyout of the membership interest at a discounted value, meaning the fair market value of that membership interest would be appraised, and then you'd take a 80 or 90%, portion of that price, and that's what they get to buy you out at without the promote incorporated in it. It can be highly punitive. So I would, watch out for this type of thing, especially as on the operator side, if you have no control over calling capital, and then, or little control over calling capital, and then, you could be stuck with these horrible penalties. Everything needs to come together in one. So when you're reviewing the JV as a whole, you need to understand what the whole package of goods is and how the different levers of control and rights interact with each other. Operators and capital partners see these capital contribution provisions often very differently. From the operator side, they want to control when capital is called and be able to really see this project through. They want the capital partner to be there to do their main job, which is write those checks. And they want to be able to, have control over the unknown and things that may come up. So if there's a cost overrun, they want their capital partner there to be alongside of them, funding pro rata their share of construction cost overruns. Of course, they prefer not to have terrible penalties for failing to make capital, though sometimes you have operators that are very well capitalized and have no problem with strict penalties for failing to make capital contributions. So the punitive nature of whether in the member loan and dilution context we're at, 8% member loan or 20% member loan, that really depends from the operator's perspective on whether they really think they're going to be the ones that are failing to make the capital contribution, or they're going to have to find a way to fill in the gap from the capital provider's failure to make a capital contribution. On the capital provider side, they want control, right? And they want rights on paper. They want to know that if something goes south, they have the right to fix it. They don't want the operator using their cash without their approval. And they want the ability to right the ship and potentially bring in another operator if things are going south. And how are they going to bring in another operator if there's a promote interest that continues to be paid to the existing operator, right? So they want all the rights and remedies, and they want the rights and remedies, including if the operator fails to fund capital, including, kick out rights, buyout provisions at a discount, the whole package of goods. Well, friends, that concludes today's episode on capital contributions. Today we talked about how capital is called, what percentage each party pays, and what remedies there are for failing to make a capital contribution. Hope you enjoyed and look forward to having you on the next episode in this series on waterfalls and capital distributions. Again, the more fun part, taking cash out of a project and making lots of money. Hope you have a great week and look forward to seeing you next time on the Mayor Law Podcast.